Um, Good morning, good afternoon, and welcome to the Legal Aid Foundation of Los Angeles presentation on how to prepare um, for an unlawful detainer trial. Unlawful detainer just refers to an eviction case. My name is Luis Mendez, and I'm a paralegal for the Legal Aid Foundation's Eviction Defense Center. And the reason we're doing this presentation is that courts are going to be reopening sometime soon or eventually. And so we think it's important to start preparing for their eventual reopening. Um, so, so who are we? Since 1929, Legal Aid Foundation of Los Angeles, or LAFLA, has provided civil legal aid to poor and low-income people in the county of Los Angeles. We have 5 neighborhood service offices in the Westlake, MacArthur Park region, East LA, South LA, Santa Monica, and Long Beach. We have 3 domestic violence clinics. We also have 4 self-help centers. These are usually located within the courts. And then in 2018, LAFLA assisted more than 100,000 people. Uh, but besides housing, we also do other matters. Uh, you can see a list here of some of the things that we can do, like employment law, government benefits, immigration, student loan issues. These are some of the topics that we deal with. Okay, so but before I start my presentation, I'll share this message with you. This presentation is designed to explain the current law as the date of the presentation. This presentation is not intended to provide legal advice or strategy on how to start or complete a legal case. This presentation only provides general information and procedures. This information is not substitute for a professional legal advice from an attorney. So please consider consulting an attorney about the specific facts of your case. Um, in addition to that, I would like to say that if you want have questions, you could leave those in the comments below. But just ask general questions. Don't put specific questions. Okay. So what the things I will be covering will be the trial process, how you can defend yourself at trial, the court's decision, and settlement agreements and or stipulated judgments. So this chart here explains the court process after an answer has been filed. So the first thing is the answer is filed. Once the answer is filed, then the landlord will request a trial date. Once that trial date is set, the court will send a trial date notice to all parties involved. And then for the first court date, you could usually use this date as a negotiation day, and you could negotiate a stipulated agreement, such as a pay and stay. This is where you agree to pay any rent or in order for you to stay, or a move out deal. And this is like how it says is you agree to move out by a certain date. Um, if no agreement is made on the first date, then the judge will schedule a second court date for the trial, right? And at trial, there's a few outcomes. Right? You can win. This could be based on a defense, which will make the landlord start over. You could also win conditional win, and in this example, it's habitability. So how this would work is if you win based on habitability defense, um, you would have to pay your rent within 5 days, and then you can stay. Or if you don't pay the reduced amount that the court determined that you should pay, and you fail to do so, then you would lose. Another outcome is that um, you would lose you lose your case at trial. Um, so if you lose at trial, the next step would be for the landlord to file a writ of possession with the court. And this is important because once that writ of possession is granted by the court, they could take that to the sheriffs, and then the sheriffs will go to your residence and post a 5-day notice to vacate, and which is a final notice. And then, if once that notice expires and you're still in the residence, then the sheriffs can come to the residence and lock you out. Okay. So now I will talk about the unlawful detainer trial. So like I said, after an answer is filed, the landlord will request to set the case for trial, and the court clerk will mail you and the landlord the trial date notice. And this notice will tell you the exact date, time, location of the trial. And like it says here, your attendance is mandatory. Um, Another thing you can consider is when you file your answer or after you file your answer is if you want a jury trial. So if you want a jury trial, there's two times where you could request it. The first one would be when you're filing your answer, you could submit the jury demand with the answer, and the second time would be within 5 days of the clerk's mailing of the trial date notice. Um, but if you want the jury demand, there's more stuff to it. You will have to make a deposit of $150, or you could file an additional fee waiver request. And besides these, you will need to submit more documents with the court, such as a general and special jury instructions, a witness and exhibit list, a statement of the case. These documents are required, and the court won't really feel sorry um, for people who aren't familiar with this. So this is something that you can consider if if you want to have a jury trial. And then the court judgment. So once the court enters the judgment, uh, and if it's against you, there's not that many things that could stop it. Um, if you appeal the judge's decision, it's not going to stop the eviction going forward, or it's not even going to delay it. The only way for you to stop it or delay the eviction is to ask for a stay of execution, and these are usually kind of are hard to be granted, um, because they depend on you showing that you have an extreme hardship, which prevents you from finding a new place or moving out of your residence. Okay, but so how should you prepare for court? You know, uh, you should bring. You should collect all of your evidence. Once you collect all of your evidence that you think that you will need, you want to make copies of it, at least 2 copies, and that way you can have 3 copies altogether. And the reason being is that you want to have a copy for yourself, a copy for the landlord or their attorney, and the judge. So what should you bring? You should bring like certified reports from government agencies, photographs. It's better to have them printed out. Um, we're gonna have letters, notices, text messages, emails, or voicemails. You also want to have proof of payment, including rent receipts, copies of checks, money orders. And if you're planning on having somebody testify on your behalf, that person needs to be there, right? A signed letter or a notarized statement from that person will not be sufficient. Um, if you're not sure whether that person will be there at trial, you can subpoena your witness if you want to ensure their presence. But if you subpoena the person, um, and if they ask, you must pay their mileage and witness fees. And again, the court will not give you more time for you to, find or collect your evidence for trial. So please do so in advance. So the day of the trial, you want to arrive early. You don't want to miss your trial date, the trial. Otherwise, you will lose. You want to dress conservatively and neatly. You want to impress the judge by showing him that you're taking this serious. Another thing to consider is that uh, no children are allowed in the courtroom because they may distract you, and they some of these topics that are discussed in the courtrooms are maybe not suitable for kids. So some courthouses have free childcare for people who have business at the court. Not all of them though. So that's something you might want to look into. And again, uh, for the day of trial, you want to bring, if you require an interpreter, you can do so. For an interpreter, it needs to be an adult. Uh, the court might not allow a child to interpret for you. You want to bring your witnesses, if you have any. You want to bring all of your evidence or proof, right? Letters, receipts, notices, pictures, and all that. You want to bring the copies of all your evidence. And and another thing you want to bring is pen and paper to take notes at trial. So when you arrive at court, um, you will enter the court. There's a docket list outside the courtroom. If you don't know which courtroom you are, you can ask a security guard. They're usually helpful for that. Um, you want to find your case on the docket, and then remember the number to the left of it. And this will be your docket number for the day. Once you do that, you want to check in with the clerk. And if you want to settle your case, you can find the landlord's attorney and ask him or them to meet with you in the hallway. Before you enter the courtroom, please make sure to turn off your phone. There are signs there, but just make sure that it's off so you don't disturb trial proceedings and once the court's in session, the judge will call your case. He will go by order of the docket. Um, but once he calls you up, you stand up, say your name, your full name, and say that you are the tenant or defendant in the case. Um, so some people use an exhibit and witness list for their evidence. And these are the two forms here. And these forms, you can find them online. So for the witness list, for the exhibit list, the plaintiff or the landlord, they will use numbers 1 through 100. And then the defendant or you will use numbers starting from 101 and above. Although you can find these forms online and you complete them online, you need to print them out, right? And then you also want to make copies of these as well. So the trial process, um, the landlord or plaintiff, or the landlord or their attorney, they will go first, and they may call witnesses to reveal or talk about why you should be evicted. Uh, Take notice of what they're saying. You could take notes. That's why it's important to bring pen and paper, and do not react to their statements, even if you believe they're lying. Um, Once the plaintiff or their attorney is done and asking questions to the witness, then you can do what's called cross-examine, and this is where you can ask the witness questions, right? So the purpose of this would be to challenge the witness testimony. Right? This is not the time to tell your side of the story. It's not the time to tell the judge that the landlord is lying. Um, you will have your chance to say your side of the story, right? So remember that this is to challenge the witness testimony. If the landlord's using documents or photos as evidence, uh, he he will give you they should give you copies of it before, right? And you also have the right to see the original. Okay. So after the landlord is finished presenting their case, or if their attorney is finished presenting their case, uh, this is when you will be able to tell the judge your story, right? So you want to be concise. If uh, it helps you, you can make a timeline so you don't forget of the events that happen, so you don't forget. The judge may interrupt you to ask some questions, and if you have witnesses at this time, you can also call them. Um, and after you finish testifying, or once your witness has finished testifying, then the landlord or their attorney can ask questions to you or your witness. Okay. Um, but once both parties have presented their case, the judge will may allow you to make a final statement in the end. And in your final statement, you should tell the judge, why you should win your case, why the facts support your defenses, and why the landlord's facts don't support his claim. The judge cannot make their decision based on the fact that you have a family or you don't have a place to go to. Okay, so now I will talk how to defend yourself at trial. And so this is going off on the previous slides where you would be telling your side of the story. So in an unlawful detainer, there are two types of defenses: technical defenses and affirmative defenses. Technical defense refers to the landlord not strictly complying with unlawful detainer procedures, and this could include the notice being defective, um, improper service of the notice, or there are rent control the notice create violates rent control ordinance. So if the landlord does not comply with the procedures, then the landlord doesn't have a standing to bring the suit or the lawsuit. Affirmative defenses, these are defenses outside of what it's in the complaint or alleged in the complaint. And this could include habitability, right, or living conditions, rent control, discrimination or retaliation, or foreclosure. Or okay, so how to present your evidence. You want to mark your photos and other evidence for identification before the trial, and this will make it easier for you to find the evidence that you're looking for or that you want to talk about. Because you don't want to be roaming, going through all your paperwork at trial. Um, Once you find your piece of evidence that you want to talk about, you can offer your exhibits into evidence. Uh, the plaintiff or the landlord or their attorney may object to the evidence, the exhibits brought into evidence, as well as the judge may not accept some of the exhibits as well. Right, and again, like I said earlier, um, you can have an exhibit and witness list to lay out all the items and names of witnesses for the court. Okay, so now I will talk about breach of warrant. Some of the defenses. So not keep in mind these are not all the defenses that there are. This is just a small sample of them. So the first one I will be talking about is the breach of warranty of habitability, and this is referring again to the living conditions in the residence. So the landlord has a duty to provide a safe and sanitary living environment and free from, holes in the walls, or on the floor, or on the carpet, missing or broken windows, um, defective electrical wiring, and such. So if you're trying to bring a defense of habitability, you must prove the following. You need to prove that you informed the landlord of these conditions, that you did not cause the conditions, you bring evidence of the poor conditions, such as photos, certified reports, witnesses, letters to the landlord. And if you win, the judge can order for you to pay a reduced amount of rent. But you want to make sure you have the money to pay. And then he could also, or they could also order the repairs to be made in the compliance hearing. Okay, so to present your evidence for defense of habitability, right? First, show the other side your evidence, and then the judge. Show the judge one picture at a time. Tell the judge the following information about each picture, right? Like who took the picture and when was the picture taken, what is the defect showing in the picture. You want to tell the judge exactly what he is looking at in the picture. After you show the pictures, you may want to explain again, how long has the defect existed? When did you tell the manager or the landlord of the defect? Did the landlord repair the defect? If you or your family did not cause the defect, you want to tell that to the judge as well. And you also want to tell the judge how the defect affects your family. Okay. This is continuing on how to present your evidence for habitability, but you should also bring, it said certified copies of health and housing department reports or any government agency report that is talking about the habitability. You also want to bring any proof you asked the manager repairs. You also bring your behalf, and the landlord or landlord's attorney may cross-examine or ask your witness questions after you have done so. Okay, and now another defense we'll look at is the notice, right? Because every eviction starts off with a notice. Almost every eviction starts off with a notice. Um, so in order for you to be legally evicted, a landlord needs to give you an opportunity to fix the problem or a notice to move out. There are different types of notices, such as a 3-day notice to pay rent or quit, 3-day notice to perform covenants or quit. This is referring to fixing a problem. A 3-day notice to quit, a 30 or 60-day notice to quit, and there are 90-day notices to quit as well. Right. So if you don't follow what the notice is telling you to do, then the landlord can file the unlawful detainer case against you. So how can you comply with the notice? Ways of complying with a 3-day notice to pay rent or quit include you paying your rent within the 3 days of receiving the notice, or if you went to pay and the landlord did not take it, um, you pay your rent by mail, and it's postmarked within 3 days of you receiving the note, being served the notice. You have receipts showing that your rent was paid, or if you have a money order receipt from the post office, or a check cashing store. That's also a way you can show. Ways to with complying with a 3-day notice to cure or quit is, you cure the violation within the 3 days of the notice, and you can send a message or prove that you fixed it to the landlord. Um, you could also do like I didn't do the things that notice claims, like having pets, extra people living there, and so on, or the claims are not material or serious enough to result in an eviction. So, what makes a notice defective? A notice can be defective based on many things, but these are some of the things, right? It could demand more rent than you owed. You can only be evicted for the rent, uh, or the landlord's overcharging you in the notice, right? Overcharge or overpaid the rent at some point and did not get credit. Um, there was an illegal rent increase, and this would be that your rent was increased over what the law allows or increased without a proper notice of the increase. You paid some fees or charges that you shouldn't have had to pay, like late fees, cleaning fees, and so on. Or you did repair and deduct, and this is where you pay for some repairs out of pocket and then deducted that cost off of the rent. Another way it could be defective is you if the landlord does a reduction of services, and this can be like if you have two parking spaces and they take one away, or if you have an extra room, something like this, like a storage space, um, and it was taken away, but your rent wasn't decreased because of this service, because of the reduction of services. Right? It can also be defective if it was not properly served. Right? And there are three ways that could a notice can be served. It can be personally handed to you. It can be posted on the door and mailed to you. And another way is a substitute service, and this is when they leave it with somebody else, and the resident who is over the age of 18 and is a competent member of the household, and they mail you a copy of the notice to your premises. Another way it could be defective is it did not declare forfeiture of the lease. It didn't give you 3 days, 3 business days to pay your rent or fix the violation. And in the case of a 3-day notice to pay rent or quit, it did not say when, who, where to pay, the times you can pay, or the person's telephone number. The next defense we'll look at is a waiver. And waiver is referring to when the landlord does something that doesn't allow him to enforce the notice that he served. And this can include like the landlord accepting late payment of rent in the past. Um, he would have waived his right to accept rent on a certain date. The plaintiff accepted rent with knowledge of the alleged breach. This is where they know about the problem, but they still take the rent. Or they accepted rent after the notice expired or the lawsuit was filed. So how you can present your evidence for a defensive waiver. And this is an example here, but if the landlord gave you a 3-day notice on the third day, on the third of the month, but you usually pay your rent on the ninth, then you can say, I show the other side, then you want to show that judge all of your rent receipts that prove that you have always or usually paid your rent on the ninth of the month and on the first. And this is referring to a modification of the agreement, right? Um, you can also have a chart ready showing that the days that you paid rent for the last year or more, and you can ask the judge to have the receipts entered into evidence. The next defense is concerning unauthorized occupants, right? So If it's not prohibited in the lease, then subletting is permitted. Rent control fair housing and other laws may permit additional occupants. Right. So, how do you prove that someone doesn't live in the unit? Government identification, like a driver's license, state IDs, school IDs, and so on. Other like important documents as well, like leases to where the person can show they're leasing an apartment in a different place, rent receipts for the new place, or utility bills as well, and other important pieces of mail like tax forms, employee records, or other bills, children's school records. This could also be used to show that that person is not living there. Okay, and then the next defense we'll look at concerning rent control. And rent control regulates how much the landlord can raise or reduce rent, and identifies the reasons for which a landlord can evict a tenant. Some laws even require landlords to pay relocation assistance for no-fault evictions in certain some circumstances. The no-fault eviction is just referring to when the landlord wants to evict a tenant based on something that, where the tenant is not at fault for the eviction, which means the tenant didn't do anything to be evicted. Um, so as of January of this year, California has rent control that covers most rental units in the state. There are some exceptions to this. This is called the Tenant Protection Act. Um, the city of Los Angeles also has rent control. It's known as Los Angeles Rent Stabilization Ordinance. And this includes like Wilmington, San Pedro, and Harbor City. Other cities also have their own ordinances, like Inglewood, Beverly Hills, West Hollywood, and Santa Monica. Um, Also, the County of Los Angeles has their own rent control ordinance. This is for areas of unincorporated, and they have their own special rules for tenants regarding evictions. So all of these laws are different and each have their own sets of rules. So yeah, that's something that you want to look at is look at your if your city has a rent control ordinance. So rent control ordinances will have a just cause requirement, and these can vary and may include variations of the following, right? Like, a just cause means that the tenant did something to be evicted, such as non-payment of rent, creating a nuisance or waste and damage to the property, breach of the rental covenant. This is referring to the rental agreement, unlawful use or illegal purposes of the residence. Um, there's a non-authorized subtenant there, and so on. And now we'll look at the City of Los Angeles Rent Stabilization Ordinance. So, if the complaint is based on non-payment of rent, uh, the landlord there are certain things that need to be met, such as like the landlord uh, failed to register the unit with the Los Angeles Housing Department, or if they failed failed to serve or post um, the written registration or annual registration renewal statement in places in a conspicuous places around the unit, such as like the mailbox or the lobby. Um, the landlord, if the unit's not registered, then the landlord cannot demand or accept rent. Um, Landlords are required to pay the systematic code enforcement program fee. This is known as SCEP, and the fee is around $12.95 per unit per year. Okay. If the landlord is alleging a breach of a lease agreement under um, Los Angeles Rent Stabilization Ordinance, then it requires that there be an opportunity to cure the violation, right? The breach was not waived, and the breach was not minor. If you live in the area under rent control, you can go to the Los Angeles Department of Housing and get certified copies of registration or non-registration of the unit and the payment or non-payment of the SCEP fees as well. Like I said earlier, the state of California has its own rent control um, statute. So under the statute, there are 11 just cause reasons. Again, so this can include like non-payment of rent, nuisance, waste, denying entry to the landlord, or subletting in violation of the lease, conducting criminal activity on the premises, or using the premises for an unlawful purpose. Uh, and the California's rent control statute also has a just cause no fault reasons, right? And this is when the landlord wants to evict the tenant, but it's not the tenant's fault. And this can be like the owner intends to occupy the unit, or they intend to withdraw the unit from the rental market, or they're complying with a government order or court order, local or a local ordinance that requires the unit to be vacant, or they intend to demolish or substantially remodel the unit. So California's rent control statute provides for relocation assistance, and relocation um, assistance is usually for no fault evictions. So relocation payment. So a relocation assistance can be a payment of 1 month's rent, or it could be where they waive the 1 month's rent, and then it must be paid within 15 days of the no fault eviction notice. If the tenant receives a relocation payment but does not leave, then the owner can recover that payment in the eviction. And this now this slide is talking about tenants who receive like subsidized housing, such like a Section 8 voucher or subsidized housing. So we'll look at Section 8 vouchers and tenants, and tenants who have Section 8 and are facing eviction, they could request a moving voucher from Section 8. Keep in mind that this can take a while for you to get, right? Because you need to first you need to find a new place or a unit that accepts Section 8. Section 8 needs to approve that unit. Right? They need to do inspections, their walkthroughs, and there's additional paperwork that they conduct as well. It can take well over 90 days, sometimes 4 to 6 months to get the moving voucher. So you could find a place and find a place, and then make sure that Section 8 approves it. Right? Sometimes your worker will not let you process the moving voucher if the eviction case is going on. So this is something that if you do receive Section 8, that you can consider. Um, and there's also public housing or low income tax credit buildings, and these usually are attached to the unit. So if you move out, then the rent subsidy or break doesn't go with you; it stays with the unit. And depending on the type, you are giving extra protections in unlawful detainer cases, more time in the notice, a grievance procedure, and complaint procedures. There are many types of these unit-based subsidies. Each of them are very different and sometimes very unique. But something that you must keep in mind is that most rent subsidies do not like it when you get evicted. Usually, if you are evicted, then you might end up losing your rent subsidy. Not always, but it can happen. And now we'll look at COVID. COVID-19 defenses. And this is a brief. If you want to see a more detailed explanation on your defenses, you could check out other previous presentations we've done. And these presentations are on our Facebook page as well. So many cities in the state passed their own moratoriums for tenants. As a result, each city's moratorium imposed different requirements on the tenants and limited what the landlord can evict. Um, Many of these COVID-19 tenant protections require, a notice to the landlord, preferably a written notice that you are unable to pay rent due to a financial impact that's related to COVID-19. Some, but not all, tenant protections require notice within a certain amount of time, like within 7 days of rent being due. Documentation of the COVID-related financial impact. This is not required in all jurisdictions. So we'll look at the city of Los Angeles. COVID. If you live in the city of Los Angeles, we'll look at the defenses for COVID-19. Right. So this applies to residential tenants who cannot pay the rent because of financial impacts related to COVID-19, who who receive no fault notices for unauthorized occupants or pets, or notices for nuisance related to COVID-19. They're protected from a 3-day notice or eviction. Commercial tenants are also protected under the city's COVID-19. If you get an eviction for rent owed during this time, this ordinance can be raised as an affirmative defense. You still do owe the rent, right? The rent is due in full 12 months after the emergency expires. Landlords and tenants can come to an agreement for repayment based on HCID's options, and you can find these on their website. And landlords are also prohibited from collecting late fees on any delayed rent during this time. And now we'll look at the county's defenses for COVID-19. Right? Again, this applies to residential and commercial tenants who cannot pay their rent because of financial impacts related to COVID-19, who receive no fault notices or notices for unauthorized occupants or pets, or notice for nuisance related to COVID-19 are protected from a 3-day notice or eviction if they give the landlord written notice within 7 days of the rent due. The landlord can still collect the rent 1 year after the emergency expires, or 12 months. If the tenant gets an eviction for rent owed during this time, the ordinance can be raised as an affirmative defense. Again, the rent is due in full 12 months after the emergency expires. Um, if you're not sure if you reside in an unincorporated area of LA County, you could go to lavote.net to check there. You just need to provide your address. And the city of the county of Los Angeles COVID-19 moratorium protects tenants who live in unincorporated areas and tenants living in incorporated cities that have not passed their own protections. So this means that tenants who live in parts of the county that are not incorporated into a city, they're protected by the county's ordinance, and also tenants who reside in cities that don't have their own COVID-19 moratoriums in place. So now we'll go into the court's decision, right? So this means that both parties have gone through their presenting their case, and now the judge may ask you to give a final statement, right? So during your final statement, you can request a statement of decision before the judge gives the ruling. And a statement of decision is just a statement that explains the reasons why you won or lost, usually in the written form for your records, um, or for the unlikely event of an appeal. Again, remember that if you do appeal, it's not stopping or delaying the eviction. Um, and for the judge's ruling, it'll usually be an oral statement, right? The judge is not required to give a written decision if the trial lasted less than 1 day or 8 hours. The judge will usually give the decision while you're still in court, right? If not, you will be notified by mail, usually within a few days after the trial. Okay, so what should the court's decision contain, right? So the court decision will tell you if you're allowed to stay, which means you won your case, or if you have to move and you lost the case. Judge would also say if you have to pay back rent or not. It would also say if you or the other side gets their attorney's fees and costs awarded. If you win and want the other side to pay your costs, then you must file a memorandum of costs with the court within 10 days after the trial. And it'll also say whether the losing side may have to pay for the winning side's attorney's fees, right? And this is if the rental agreement says that the prevailing party get their fees paid. Um, and if you win on a habitability defense, then the judge will order you to pay at least a portion of the back rent, and that must be paid within 5 days. If you pay on time, then you do not have to move out. But if you fail to pay the back rent on time, then the landlord can file a writ of possession, and you will have to move out. If you win and the judge does not make you pay the back rent, the landlord will may serve you with a new notice to pay the rent or quit. And then if you do not pay the rent or do not move out, then your landlord uh, may restart the whole process again. And we'll look at the court's decision if you lose. So if you lose, you can ask the judge for more time to move out. If you need more than 7 to 10 days, you can ask for a relief from forfeiture. And this is a, a motion based on extreme hardship. Right? And you can do this if it's appropriate, right? To be granted a relief from forfeiture based on hardship, you must be able to make the landlord whole. And this means that you pay back the rent, the cost, and the attorney's fees. And you could ask for it by saying, with all due respect, Your Honor, I request 30 days to move. You want to make sure you can explain why you need more time, and you may have to pay rent for that extra time if the judge grants you more time. If the judge does not give you more time, don't panic, right? You do not have to move out that same day as your trial. The landlord, there's still things the landlord has to do, right? The landlord still needs to get a writ of execution and take it to the sheriff, and the sheriff has to process the writ and serve that 5-day notice to vacate. Um, the sheriff will post that 5-day lockout notice, notifying you, when you need to leave the residence. After those 5 days are over, then the sheriff returns and will escort you and your family out of the unit. And remember, only Los Angeles County sheriffs can perform the lockouts. So this is a picture of what a notice to vacate will look like. As you can see, it's a white piece of paper with red writing. Right, it'll contain a date, and that'll be the last date that you can be there. If you're there past that date, the sheriffs can come in and, like I said, remove you from the residence. Um, if you wait till the last minute to move, the shares, they won't give you time to pack your things. They may give you 5 minutes to grab whatever you can, and you will be escorted off the premises. The locks will be changed, and you will be ordered not to return. Right. So it doesn't matter if you have like small children or somebody has a disability or sick. Right. If so, if you get locked out without your personal property, uh, you have 15 days to contact the landlord to get them back. If you don't, then the plaintiff can either keep them, dispose of them, or sell them. Okay, and the last thing we'll look at are settlement agreements or stipulated judgment, and this is a two this form you could is available in the courtroom, and there's also a fillable PDF form on the court's website. Right, if you go to lacourt.org /forms, it'll be under the unlawful detainer forms. So I will show you. I'll explain the form so you can understand it and what it's asking. Right. So the first thing you need to do is fill out that caption box, and this is pretty straightforward. Right. You will need to write the court's address, write the plaintiff's name, write your name, and when you're writing these names, uh, you need to make sure that they match what's on the summons. And you want to write your case number and the department number as well. So for number one here, this is where you will write your name as well as any other defendant that's going to be signing the stipulated judgment or settlement agreement. The names here should match as they appear on the summons. Otherwise, the court may reject it. And we'll look at number two here. In number two, it's talking about uh, the judgment, right? So this is talking about if there's going to be a money judgment, and if there's going to be a money judgment, this is where that would the money listed will be. So as you can see on the left hand, there's multiple lines where it says past due rent, holdover damages, attorney fees, and costs. Um, so if you and this will be the amount. If there's any amount listed here, this is the amount that you will owe your landlord, right? You can negotiate this amount, but once the judge signs off on the agreement or stipulated judgment, the landlord can collect the balance through like garnishments, uh, bank levy, or a lien on personal or real property. In this example here, the judgment is for $2,000, right? And the landlord can start trying to collect the $2,000 now once this is signed, right? And that $2,000 is based on, in our example here is that there's $1,000 due in past rent. There's $500 of holdover damages and $500 for attorney's fees, which will come to a total amount of $2,000. Right. So this is what the money judgment will be for. And when you're negotiating, right, you want to pay attention to the numbers listed here. Otherwise, um, you want to make sure that you're comfortable with the numbers listed. Otherwise, it can present problems. Right. And to the right, you could check the two boxes here. Right. The first box says that defendant rights under the lease or rental agreement are forfeited. This would be marked if when you're electing to end the agreement, your rental agreement. And the bottom box is plaintiff is awarded possession of the premises located. And this is so in this one you will write the address of the residence as listed on paragraph 3 of the complaint. Right? You need to make sure it matches, otherwise it might be rejected. Okay. So now we'll look at number three. And number three is talking about security deposit. All right. So the first box is regarding whether if the first box is marked, then the landlord or the plaintiff will return to you the security deposit, and they have 21 days to do so. And after you vacate the premises, right? And the deductions over $100, the landlord must provide you with an itemized list of each deduction. Right? Any disputes over the amount can be settled in small claims court. The second box is referring to if the second box is marked, then the landlord is allowed to keep part of it. Part is allowed to keep the Social Security deposit as part of the agreement, and you can no longer claim it. Right? If there is no security deposit, then you can leave these blank, or you can write in that there is no security deposit. And in number four, this is talking about when the judgment shall be entered. Right. So if the first box is marked, then the judgment is entered that day. Right. The second box is marked, then the sheriffs cannot lock you out until the date that's listed on that line. Right. In our presentation, we have a date of January 1st, 2020, and that'll be right. The sheriffs wouldn't be able to lock you out until this date. In the third box, right, you this is if you can stay you can stay unless you do not do what you promised to do in paragraph 6. Right. The terms in paragraph 6 are on the next page. Right. This is the fine print and important that you are that they are followed to exactly. If you do not follow the terms exactly, you may be evicted. Right. So we'll, we'll move on to number 5 here. And number 5, the day that's the right here, this will be your last day in the unit. You're agreeing to take everything with you, right? So your furniture, clothes, trash, pets, and everything that you own. Anything you leave behind can be disposed of or kept. Pictures of your unit to show that you left it the way you found it. You do not want the landlord to blame you for any damages or clean up. You can also get a receipt for the keys when you leave or vacate your unit. You need to be able to prove that you left on time. You can prove that you vacated the unit on time or that you vacated, and the plaintiff can come after you for breaking the agreement and unseal your rental record and get money damages from you. And so we'll look at number 6. And like I said earlier, number 6 is very it's important because it talks about the fine details of the agreement that you and others, the plaintiff, are entering, right? So any terms or conditions will go in number 6, right? These terms must be followed exactly. If they're not, then the landlord can say that the terms were not followed and get the eviction or lockout immediately. Right? If this happens, there may be a short hearing on whether the breach occurred, and sometimes this is done by declaration, which means that the landlord just has to sign a piece of paper um, listing, declaring what happened and you caused that breach. Um, and then he has to file it with the court, right? And then the sheriffs will come out with a 5-day notice to vacate, in usually about 10 days. If you're allowed an evidentiary hearing, right, the judge will only look at evidence that says whether there was a breach or there was no fault. If there was a fault of the agreement, the judge at the evidentiary hearing, the judge will not consider evidence about previous defenses, in your case, problems in your place, what the landlord said, or you did to you previously, right? But they were only considered if whether you lived up to the agreement, to the terms of the agreement. Um, and number six, some of the common things people can ask for is um, the the record to be sealed, right? And this means that the eviction will not go on your credit history, and this will stop it from negatively impacting your credit. A neutral credit reference, and this is referring to the landlord will give you a neutral or non-negative reference for future landlords. This is helpful when you're applying to for new housing. Receipt for keys, right? So when you leave, the landlord will provide a receipt for your keys to prove that you left. Remember, if you don't, um, remember if you don't provide that a landlord, then the landlord can say that you did not move out on time or timely, and get the eviction on your record. And then you also want to be aware of any additional terms as well. So in number six, you want to read whatever's written here very carefully. So in number seven, this is in case there's an agreement of a payment plan, and the details of that payment plan will go here, right? So if you if you fail to follow the payment plan exactly, then the landlord can file a writ of execution and evict you. Right? Thus, if you agree to a payment plan, make sure that you can make the payment for sure and exactly how it is laid out. If you do not, you will be evicted for not making the payment or performing the agreed terms. Excuses will not work. And we'll move on to number eight. And in number eight, if the box for number eight is marked, then you are giving up your right to bring any post-trial motions. Thus, it is imperative that the terms or conditions that you agree to, you can achieve them. And then number nine, this is where you will need to date, print your name, and sign the form. Right? Like I said earlier, once the parties sign onto the agreement, the judge will sign it and date the form, and this form will then become a final court order, and all parties involved will need to follow it. There are no do-overs, or or if you change your mind, it can't be changed after the judge signs it. Okay, so if you want to contact us, you can do so by applying online at lawful.org/help, or you could call us. Our phone number is 800-399-4529. From Monday to Friday, the hours are from 9 a.m. to 12 p.m. Or you could attend a lawful clinic. Uh, the address is lawful.org/self dash help/calendar. And now I can answer any questions that are in the chat, or if you want, I can answer general questions in the chat. But if you have specific questions, you could call our numbers, and that ends the presentation.